Are activist judges trying to block the Trump administration's immigration, DOJ, cultural, and defense policies? The country has already seen court rulings putting a halt to deportations, DOJ access to government finances, and transsexuals in the military. White House Press Secretary Karoline Leavitt refers to the rogue judges as part of the resistance to Trump movement.
Almost every single one of them is a registered Democrat, has been involved in Democrat campaigns or causes, have donated to Democrat candidates. Some of them have even put their anti-Trump bias on social media. They have not been shy about their hatred for this president and his policies, and they are abusing their judicial power.
Joining us with more is former Trump legal advisor Jenna Ellis, who currently serves as senior advisor of public policy at the American Family Association. Jenna, thanks for being with us. So do you agree with Karoline Leavitt? Are these judges, activists, Democrats trying to stop Trump's agenda through the judiciary?
Well, thanks for having me, Gary. And I do agree with the White House, but I think it goes even deeper than that. The leftist agenda for decades has been anti-Constitution and just preferred outcome. That's what it means to be an activist, that they just want to get to their preferred outcome regardless of what the rule of law says. And so we see that even with the lawfare that was against President Trump, it doesn't matter what the rule says. It just matters what outcome they prefer. And so judges shouldn't be activists. They shouldn't be making decisions based on political preferences or categories. They should be following the rule of law so that it ensures that we as Americans can truly have a well-ordered society.
Well, let's look at a couple of these. Polls show a majority of Americans support the deportation of criminal illegal immigrants. So is there any legal basis for judges to stop deportation? It seems a valid argument can be made that judges are venturing into the foreign policy arena, seizing powers that belong to the president. Your thoughts?
Yes, especially the D.C. District Court Judge, Judge Boasberg, who Congressman Brandon Gill is filing impeachment articles against. And I fully support that because that is the remedy that our founders provided for activists or anyone in federal elected office, an officer under the United States Constitution that goes well outside the scope of their authority. And so let's just take that instance. Article 3 judges cannot second guess the execution of policy. That's a decision that we, the people, made when we elected Donald Trump in November. So it's not just that this is a policy preference that the majority of Americans support. It's that Donald Trump was elected to office to execute the office and the powers that are given to him as the president under Article 2, Section 1 of the U.S. Constitution. That's not for Article 3 judges to second guess or to determine their opinion and stop him based on their own policy preferences.
I think the same argument can be made about the judge blocking Pete Hegseth and the DOD from implementing a ban on transsexuals in the U.S. military. Defense Secretary Hegseth suggested that the judge should report for duty since she's now a military planner. But isn't a judge acting within their authority, though, Jenna, when they believe the Pentagon is making unconstitutional military decisions?
Well, we have to understand what the term unconstitutional means. Again, the left has tried to harness that language and redefine it. It's not a matter of what anyone believes should happen in the policy realm. It's what an officer under the Constitution can do with their limited powers that are given to them under the U.S. Constitution. And so if Pete Hegseth, as the DOD secretary, can instruct his agency in a certain way, then it's not for our Article 3 or federal judges to second guess that. Whether or not he should is the policy question that they can't contemplate. And so the only way that it becomes unconstitutional is if he goes outside the scope of what executive authority, the limits and the guardrails of what executive authority is given to a president and his subordinates under Article 2. And so as Americans, we need to go back to our U.S. Constitution, understand the limited and separate powers that our founders provided so we understand how and where judges can act, what's within the scope of their jurisdiction and judicial review, and what isn't, and what makes them activists.
Okay, looking at remedies, you already talked about impeachment, but House Speaker Mike Johnson says Congress has broad authority over the federal courts and can eliminate an entire district court by pulling their funding. So is that a possible solution to stopping judicial activism? What do you see happening there?
That's one possibility. So, under the Constitution in Article 3, only the U.S. Supreme Court and justices, but it's not numbered. So, we could have more than 9 justices, for example. That's all done through the legislature, through Congress, and currently the Judiciary Acts. And so, if Congress wants to revisit the circuit courts, they want to revisit funding, all of those things, they absolutely can under the Constitution. And Congressman Andy Biggs also floated another solution, which I think is a very interesting legal question. He's now running for Arizona state governor, but he suggested that because Article 3 judges only are given a lifetime term of good behavior, that Congress, by simple majority resolution, if they find that those judges are not acting within good behavior, whatever that means, then they could simply pass a resolution based on a simple majority to eliminate and remove those judges. And so that, of course, would be far easier than the impeachment process and would also be far easier to get through the filibuster that's in the Senate.
Finally, I've got to ask you, you recently wrote an op-ed about President Joe Biden's use of the autopen to sign presidential pardons. Does the law require the president to personally sign the pardons and legislation? And why would an autopen invalidate the pardon or legislation?
I don't believe that it does, and we've seen historical examples of the use of an autopen. So I don't think that it runs afoul of the presentment clause or any other constitutional parameters just solely based on the use of the autopen. Where I think the legal question gets interesting and ventures into the realm of possibly voiding those pardons is if Joe Biden didn't himself order them, if he didn't form the requisite mental intent and discretion that is only given by the Constitution to a president. He can't delegate it. It's called the non-delegable doctrine. And so if his staff was making these orders and pardons by use of an autopen without his authorization or authority, then they would have been circumventing the power that's vested only in a president of the United States. And that could render those pardons or executive orders voidable.
Okay, we'll see what happens there. Jenna Ellis of the American Family Association, thank you for joining us. We appreciate it.
Thanks, Gary.